Hello, everybody. Hello, C-Rex. Don't you start with me. Hello, Eileen Carlin. Hello, Michael Psycho 1. Hello, Ava. My goodness. She's here for it. She is here for it. The treats, and the stream. Yeah. I put together a live collection of stuff to run, so we can all just sit and enjoy some clips together. Hello, love. Good to see you. Yeah, I didn't feel like editing right now. That's what I would normally be doing, but I didn't feel like it. I wanted to spend time with you guys live instead. It's so much better. Hello, Charlie. So good to see you. This attorney is a piece of work. Yeah. Hello, Jerry Matthew Boyd. I'm on a loading screen, so I can't put your name up there, but I see you, babe. Ava, just chill, baby. I know there's one more. My goodness.
Go hard here this morning along with Mr. Olafson, so we can proceed with arraignment, and prosecutors here as well.
Okay, great. We'll go ahead and call the Chad Olafson matter.
Morning, Judge. Bo Harlan appearing on behalf of Chad Olafson, and there's actually two matters: the infraction I filed also appearance on, but most importantly is the DUI. That's case number 5A04528084. We will waive a reading of any citation or charging document under plea of not guilty and ask for dates in ordinary course.
All right, thank you. Sir, can you please state your full name?
Chad Fergus Olafson.
Thank you, sir. And what's your birthday?
10/1/1976.
Thank you, sir. You're here for your arraignment on one count of driving while under the influence. That's a gross misdemeanor, carries maximum penalties of 364 days in jail and a $5,000 fine. Not necessarily what you would be sentenced to, sir, just the maximums you could be sentenced up to. You're absolutely a gross misdemeanor. Your attorney has indicated that you're going to enter a not guilty plea today. All that does is preserve all of your rights. We're going to waive the formal reading. Your not guilty plea will be accepted. I did review this case prior to this morning, and I did find there is probable cause. I'll hear from the prosecutor on recommendation for release. Ms. Carmi?
Yes, Your Honor, we are asking for beyond standard release. I think there is a mandatory component here that we at least have to have. There is a 2012 prior DUI that he pled guilty to. This is a blood draw case, so obviously we don't have the benefit of knowing what the BAC level is. Often if it's a lower BAC and there's a prior, I'll recommend ignition interlock or random UAs. If it's higher, I'll typically recommend scram on a second DUI. I just don't have the benefit, obviously, of knowing that. So the only thing I can go on is what I'm reading in the report. And sorry, I'm just getting Zoom started at the same time. I apologize. And what I can tell the court from the report that affects my request and has me leaning towards requesting that this court implement scram, which is a higher level of monitoring, is Statements made at the scene, officers' indications that there were statements like, you know, I'm the guy who bought your department Christmas dinner, so I'm not doing any tests. He very obstinate at the scene with officers, making a lot of comments about why he should not be arrested, why they should just let him go. So I do think that scram is appropriate in this case.
I would personally if I like to be, are you done? Council?
I'm done.
You go ahead, Mr. Harlan.
Didn't mean to interrupt. You know, when we look at the declaration of probable cause, and that's all we're dealing with here, you know, there's common signs of DUI and somebody being grossly intoxicated. One of those signs is obviously that we always hear about is slurred speech, bloodshot, watery eyes, poor coordination, poor manual dexterity. You know, giving somebody a credit card instead of an insurance card, not being able to find their registration or proof of insurance. That's not the case here. None of that's the case here. You read the probable cause statement, there's not even any indication of slurred speech in the slightest. There's no indication he has poor manual dexterity. There's no indication he has any broad-based coordination issues. These are all things that a trained police officer should put in the probable cause statement. It's not there. So
Well,
if it's not there, you got to presume it didn't happen.
Not
So-
when he refused. He refused
I didn't
all of that
interrupt you.
testing.
I didn't interrupt you. Counsel.
Ms.
Well,
Carmi,
there-
I'll give you a chance to respond very briefly. Go ahead, Mr. Harlan.
He has every right not
He
to do it. He has every right not to do field sobriety tests. That doesn't mean there's not evidence of poor coordination or manual dexterity. All that being said, I'd ask for the minimum. I mean, Mr. Olafson's been a lifelong resident of this community. He's not a flight risk. He's not a danger to this community. So I prefer and I propose the minimums in this circumstance. That's appropriate, not scram. He's not a criminal. And based upon the probable cause here, the city's not getting a conviction here. So I'd ask for the minimums in this situation.
All right,
Well-
very briefly, any response, Ms. Carmi?
Yeah, I think that that's a gross mischaracterization of the case. He, as I stated previously, there is indications in the police report that when they made contact, he was doing things like rolling his window down just a little bit, handing out a card, rolling it back up. They did notice watery eyes. And the case law tells us that we can presume that he would have failed fields because he refused them. So we don't know what his BAC level is because he refused all testing. So we have to err on the side of community safety. And it sounds like, Judge, after you're done, we should probably just set this for trial from today's speedy trial.
All right, last word to you, Mr. Harlan. Anything briefly in response?
You know, somebody exercising their right not to do field sobriety tests. I don't think you can presume he would fail them based upon that. Again, there's no indication he had poor broad-based coordination. The infinite report, there's no indication he had slurred speech. You know, this is an officer sitting at a known bar and waiting for people to leave and pulling people over. That's what this case is all about. So again, I think that the appropriate thing here is the minimums as it relates to any type of conditions of release.
All right, thank you to both counsels. I appreciate the arguments. I did review the probable cause statement. It is fairly detailed in length. The court's considering for conditions of release whether the community is at risk as well as whether the defendant is a flight risk. I do have some community safety concerns based on what's contained in the probable cause affidavit, that it's alleged that the defendant was driving the wrong way on the roadway. There was a strong smell of alcohol from the defendant's breath, watery eyes, and the defendants made statements such as, quote, if I blow, it's going to be over 0.18, and quote, I've been watching golf and drinking all day. So I do have some concerns for public safety. However, we do not have any blood results. We do not have a BAC at this point in time. So I'm going to give you a chance on supervised release without a scram device. You are going to be on the administrative supervised release level with the ignition interlock device. Mr. Harlan, does your client have a vehicle, or is he looking at is he looking at a declaration instead?
No, he has a vehicle, Judge. The only thing I'd ask is, could we get a couple days to get that installed? He's actually leaving town for the weekend, coming back Monday or Sunday.
Ooh, the prosecutor does not like that, not even a little bit. Her facial expressions just, yeah, she's got no poker face. She gives it all away.
If I give him 10 days, is that going to be enough time?
Excuse me?
10 days instead of the 5?
That'd be great.
Any objection to the 10 days based on the travel, Ms. Carmi?
Yes, we do object and we want it done in 5.
What's the specific travel dates of your client?
He's leaving right after this hearing, comes back on Sunday,
Sunday, late afternoon.
Sunday late afternoon. So if we could do it next week, by the end of next week, be fine.
I'm gonna order the ignition interlock installed within 1 week of today. That is 7 calendar days. It must be installed by August 21st. Gives you enough time, sir, to have a couple of days after you get back to get that installed and provide proof. Must be installed by August 21st due to travel. You're going to be on administrative supervised release, sir. This is a strict compliance scenario. If we have any issues with supervised release, we will be looking at increasing that and potentially adding the scram. Ignition interlock by August 21st, administrative supervised release. Your other conditions are going to be standard DUI conditions. Violate no laws, appear at all of your mandatory court dates, including the next one that I will give you momentarily. You're going to let us know and let your attorney know if you change your address or your phone number. You are not, sir, you are not to possess or consume any alcohol or non-prescription drugs during the pendency of this case. You are not to drive without a valid license and insurance. And again, you will get that ignition interlock installed by the 21st, and you will check in, sir, with pretrial supervised release before you leave for your trip. Mr. Harlan, work with your client to get that done as soon as possible before he leaves so they can at least get his phone number.
Does he need to go down to the courthouse and check in down there? Or how does he do it relative to the battleground? I'm not sure.
There's a number on the order that should be sent to the court that they'll need to call and then set up the appointment with supervisor.
Okay, great. Thank you. Perfect.
Yep, the phone number will be on there that he can call. And then in terms of forward court dates, my next court date is October 23rd at 3 p.m. If that works for the parties, that would be still within speedy, but that's going to leave us a little bit of limited time if we're looking to set within speedy parties' positions on October 23rd.
I have no objection.
With a waiver,
No waiver coming from this side.
then we're going to need a different date.
Let's see if we can do. Let me just look at my calendar really quickly if I have anything before that. Give me one moment, folks.
And are we going to contemplate setting for a Tuesday trial? Because then we could use October as the readiness date. But I don't want to set out to October unless we're setting a trial date.
I think it's probably a one-day trial. That'd be my expectation, but
Well, I could come back and do a September date if that's better for y'all and you want to check in earlier, or if you just want to set for trial at this time, I'll ask Madam Clerks to look at the calendar for dates.
So, currently right now, I'm gonna defer to a prosecutor. We have jury trial set for September 16th, the 23rd and the 30th. And we can do the readiness any Thursday in September at 3 p.m. will accommodate the schedule.
Do we have any October trials set yet?
We do know.
I can do any Tuesday in October, so I'll defer to defense to pick a date. If we set it for we set it for November 4th, we could keep the October 23rd as readiness.
we can do that.
All right, parties in agreement, October 23rd at 3 PM for readiness. And then November 4th, that'll be 8:30 AM for trial. Sir, those are your next two court dates. They are mandatory court dates. You do need to appear for both of those. Again, October 23rd at 3 PM, November 4th at 8:30 AM. Stay in contact with your attorney in the meantime. Mr. Harlan, anything further from your perspective?
No, nothing at this time. Thank you, Judge.
You're welcome. Ms. Carmi, anything further from your perspective?
No, Your Honor, thank you.
All right. I'll send over the paperwork here momentarily, and then, sir, stay in contact with your attorney. You're free to go. Thank you all.
Yeah. That attorney was a little ballsy and arrogant and he's, I'm not the biggest fan of his.
What else do I have? Perez, Forrest Michael Perez, 25B148508.
Morning, Your Honor.
Your name, sir?
Forrest Perez.
Okay, officer, good morning. Your name?
Officer Cameron Grimsley.
Good morning. You ready to proceed?
Yes, sir.
I'll ask you both to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Officer?
I do.
Mr. Perez?
I do.
Okay, go ahead. You can proceed.
Your Honor, it's my understanding he wants to fight the ticket
Correct.
today. He was issued failed to yield for an accident. I've sent a video of the accident to the court.
Do we have that, Lisa?
I have it. Yep, I can do a share screen if you want to see it.
Sure.
Okay.
Do you want to tell me what happened first while she's loading that?
Yeah, so, Mr. Perez was northbound on Allen Road. Went into the left turn lane to turn westbound on the Sibley. The light was blinking red at the time, and he didn't yield. The other vehicle was south on Allen. The light turned yellow.
Guys, give me just a second. Yeah, the cord got sat on. She's running and hiding right now. But I'm loading the computer back up. So yeah. I switched the plugin, so hopefully she won't be able to ever do that again. Yeah, this is Fantastic. And I have to turn my mic volume off now. Oh. Hey, I did that without feedback. Yay, proud of me? Oh my gosh. Okay, so yeah, I've switched the cord so that that can't happen again. I really hope. Arg. So it restored the pages, but it didn't restore my bookmarks. That's okay. Give me just a moment. I recognize, people and I just gotta find my place. Billy, stop sitting on the keyboard. Oh my God, these animals. Okay, I promise. We're gonna get there. We're gonna get there. Okay. This guy is right here. Okay. Just wouldn't be an April stream without all of these issues. Okay, it's right after this dude. Why does it keep doing that? It keeps going back to the beginning. I keep putting it at the right spot, and then it keeps going back to the beginning. Like, I am getting just a little irritated. Dear YouTube. Okay, I see the dude. I see him in the crowd. And there he is, right there. So now just back him up just a tad. And play.
Perez, Forrest Michael Perez, 25B148508.
Morning, Your Honor.
Your name, sir?
Forrest Perez.
Okay, officer, good morning. Your name?
Officer Cameron Grimser.
Good morning. You ready to proceed?
Yes, sir.
I'll ask you both to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Officer?
I do.
Mr. Perez?
I do.
Okay, go ahead. You can proceed.
Your Honor, it's my understanding he wants to fight the ticket
Correct.
today. He was issued failed to yield for an accident. I've sent a video of the accident to the court.
Do we have that, Lisa?
I have it. Yep, I can do a share screen if you want to see it.
Sure.
Okay.
Do you want to tell me what happened first while she's loading that?
Yeah, so, Mr. Perez was northbound on Allen Road. Went into the left turn lane to turn westbound on the Sibley. The light was blinking red at the time. and he didn't yield. The other vehicle was south on Allen. The light turned yellow, but he was close and he proceeded into the intersection. Mr. Perez turned into the other unit and caused the accident.
Okay,
See it?
yeah, I can see it great.
Okay.
Thank you.
All right, give me 1 second here.
Take your time. Oh, geez. Why aren't you responsible for failure to yield after seeing that?
After saying that, I don't know that I have a charge.
You have,
The way that I felt it happened was that this car had stopped and this car was fine.
you know you still have to stop on a flashing red, right?
I wish I had seen the video before.
That's okay. You're fine. All right. I'm gonna find you responsible as charged. I'm sorry, 195. Can you pay that today?
I can't.
When can you pay this? Yeah, I'll give you until the 28th. If you need more time, call the court. And we'll go from there, okay?
Thank you, Your Honor.
Thank you very much. Thanks. Is this your first hearing in here in front of me?
Second, I was unprepared the first time.
Did I tell you that?
I was in here with a younger gentleman and he wanted to plead to something, but,
You're fine.
Yeah.
You're fine.
you know.
Good to have you. Good luck, sir. Thank you. All right, Clanton. Quentin Antoine Clanton. 25G306486. Okay, your name? All right, you're gonna keep that child in school, right?
Yes, sir.
Listen, I'm gonna adjourn it one last time. If it doesn't resolve next time, I'm gonna have to set it for trial, okay? But they're gonna talk to him. They want to adjourn. It says adjourn for defendant to talk to school next week. We'll make it August 28th, right, Lisa?
Yes, 9:30.
At 9:30 in the morning, okay? All right, good luck to you. Thank you.
That was really the only one that I snagged. I don't know if anything else is good. I mean, it's Judge Dad, so it, of course, good. So expressive.
I don't have anything else. I'm gonna start that. Give me that. I don't have anything else. I'm gonna start that. Give me that file, please. That felony. People against Pitaway. Donald James Pitaway. 25B718-080.
Good morning, Your Honor.
Good morning.
For the record, Ian Caldwell, B67486, I'm going to Mr. Goodaway.
Mr. Pitaway, your name?
Donald James Goodaway, the second.
So your client charged with felonious assault.
Yes, Your Honor. This is my client, Stan me waive a formal reading of the charge.
All right, I'm gonna go ahead and advise you of your rights. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by your lawyer at all subsequent court proceedings. Also, if you ever choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that question. Do you understand that?
Yes, I do.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary exam within 7 days thereafter. At a probable cause conference, your lawyer will discuss the case with the prosecutor. If it goes to the preliminary exam, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
I understand.
All right, we're gonna do August 26th at 9:30. And then that's September 2nd at 10:45. Those are going to be, you're going to be in front of Judge Hessen
August 26th,
at 9:30 for the PCC. And then September 2nd at 10:45. I'll let you speak to bond.
With regard to bond, Your Honor, my client's 56 years old. He has no prior felonies. He's a Brownstown resident. He's gainfully employed, works for Allied Universal Security. He's been there for 10 years. He's security at the Marathon Refinery, which is a federally protected facility. Judge, once he found out about this, he called me, made arrangements to take care of this. Brownstown informed there's a bunch of work. He's not a flight risk judge. He's going to come to all court cases. We asked for personal.
This is his brother, right?
That's my understanding, is the allegations from the brother. I haven't seen any discovery.
I understand.
The detective's out there, Your Honor.
Okay. Detective Tulas, your appearance.
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
All right. They're asking for a PR bond. What is your position on this?
Your Honor, we'd have no objection to that. We would just ask that he have no contact with his brother. It's my understanding that Donald Pittaway does not have any current or recent criminal charges. I believe he had 2 prior assault charges that stemmed from incidents that occurred back in 1992, but they were not felony charges.
Yeah, I understand. I mean, he had a couple little minor matters, 92, 97, but that was actually an ordinance violation, false information that disturbed the peace in 94. So I don't have any problem at all with this. $15,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with Ronald Pittaway. You cannot write him, phone him, see him, text him, email him, or have anybody else do any of those things for you or on your behalf. You're not to have any contact with prosecution witnesses except through your lawyer. He's not been printed yet either, right?
That is correct, Your Honor.
And remind me, where does the victim live? Was it?
The victim is currently residing in our Tella Valley Mobile Home Park. It would take me a minute to get up his address, but it's not near where the where Mr. Donald Pittaway resides. He's residing with his with one of his friends.
So I'm not to enter the Tella Valley Mobile Home Complex. You're not to possess firearms. You're not to possess dangerous weapons. Any weapons have to be surrendered today to the Brownstown Police Department. And you do have to go over there. He's not been printed, so we're going to have to go over to Brownstown Police Department to be fingerprinted and photographed by August 14th, today at 1 p.m. You can go there anytime, but by 1 p.m. And I'm going to sign that order, and we'll go from there.
Your Honor, with regard to the firearm, my client does have a CPL through his employer, employment with the security. Is there a way to keep the, just for work purposes?
Where does he take the gun at night?
I don't, our account's unarmed.
Pardon? So you don't carry a gun?
Oh, okay.
I have a CPL, but I don't.
Okay, I thought it was for work.
That's all right. Don't worry about it. I understand.
Just want to make sure. Okay, so that's not.
No problem. Okay, good to see you, counsel.
You too, Your Honor.
And you'll go down the hall, get your notices, you'll take your order for print, you'll take your copy of your bond sheet and go over to Brownstown, okay? Best of luck to you. Thank you.
Thank you, Your Honor.
Thank you very much, Detective. Thanks. Someone, let's see. Is Crystal Diamond Davis in here? Come on up here, please. Crystal Diamond Davis.
I apologize, guys. I am trying to frantically restore all of the dockets that I was in the process of downloading and that went bye-bye. So I'm just gonna leave Judge Dad run for a minute, and then we can get back into the stuff that I had planned on streaming.
And also Aaron Jordan Kennard. I have Davis is 25G306520. Kennard is 325G306491. Right. Your name, ma'am?
Crystal Davis.
And your name, ma'am?
Aaron Kennard.
Good morning. So ladies, you have the right to a lawyer here. I'm going to think this through. How many lawyers do we have that could pre-try these today, Lisa? Do I have?
Yeah, we have an overflow here that can take one of them.
So when a lawyer represents two co-defendants, there's always a potential for a conflict of interest, all right? Somebody might say they didn't do it, the other person did it, I didn't do it, they did it, what have you. If you want a lawyer, I'm gonna get you a lawyer. I can set you up with each with a lawyer today, and then you'll come back in front of me. Would you like a lawyer, Ms. Davis?
Yes.
Would you like a lawyer, Ms. Kennard?
Yes.
Okay, so you guys go out in the hall, and my court officer will set you up with a lawyer, okay? Yep, right, go right out. Good luck.
Thank you.
Chelsea Leanne Eldridge, 25T645-759. Oh, you have a lawyer too. Mr. Gaith, are you on this one? Mr. Gaith? Who is your lawyer, ma'am?
Hello.
Mr. Gaith, can you log in on this Chelsea Eldridge, please? I think that's yours.
Yes, Judge.
Thank you.
Yes, thank you.
So those both need separate lawyers, co-defendants. So we're gonna give them separate lawyers. He's on his way in, ma'am.
I'm here, Judge.
Okay, your appearance?
Mazen Gaith, appear on behalf of Ms. Eldridge.
All right, and your name again, ma'am? Nice and loud.
Chelsea Eldridge.
All right. So for purposes of arraignment, does she stand mute and waive formal reading?
Yes, Judge.
I actually already arraigned her, then she said she wanted a lawyer. I've entered a not guilty plea. I've given her a personal bond already. I enunciated those terms. We'll adjourn this to what, August 28th, Jennifer or Lisa?
Yeah, August 28th at 9:30.
All right, thank you. So you're gonna go down the hall, you're gonna get your date. But first, do you work, ma'am?
Yes, I do.
Where do you work at?
I work at SOS, assessing the spectrum, take care of autistic children.
How much do you make there?
I make 18 an hour.
Okay, can you afford your own lawyer?
No.
All right. Lisa, I'm just gonna have her fill out a petition down there if I can, please. John's out of the courtroom. And I'm sure I'm gonna appoint her a lawyer. So you go down the hall, get your notice, fill out a petition, so you can have a lawyer going forward then, okay?
Okay, thank you.
Thank you.
Judge, I just want to make sure there was only one of the files that was marked as arraigned.
What's that?
There was only one of the files. She's got two A and B case.
Yeah, I advised her. I just didn't mark the one up. To
Okay.
leave the scene and the other one, leave the scene and drive while unlicensed. Yeah, I did arraign her. I just didn't mark the other one up. She was just in front of me about 15, 20 minutes ago.
Okay.
Thanks.
Thank you, Judge.
Good luck.
Thank you. Thank you.
You want to do Diamond Gee now? Is that your,
That's mine, Judge. We can do that.
okay? Let's bring in Elizabeth. All right, people against Diamond Mercedes Gee, 22B 141007.
Diamond that's her real name? Okay. Usually that's the name that I hear as a chosen name. Typically well around a pole.
Good morning, Judge. Mazen Gates appearing on behalf of Ms. Diamond G.
Your name, ma'am?
Diamond G.
So, counsel, it looks like on July 8th, I sentenced her, or
I was under the impression, Judge, she was being sentenced today, she wasn't being arraigned.
no, I know, that's exactly right. And I'm trying to read my notes. I had a hearing, and I found her guilty. I dismissed count 3 and count 4. And I don't know if she pled. Lisa, maybe you can tell me. I didn't make very good notes that day. She pled to 1, 2, and 5, or was found guilty of 1, 2, and 5. That is failure to attend a scheduled visit on May 30 of 25, failure to attend a probation visit on June 11 of 25, and failure to provide verification of attending and completing outpatient treatment. So she was found guilty on those dates or pled guilty. Can you discern that, Lisa?
I might be able to clarify for you too,
Your
Judge.
appearance?
Elizabeth Wilds, probation, Your Honor. You did find her guilty on counts 1, 2, and 5. Counts 3 and 4 were dismissed. Those were at times in which she was in the hospital due to giving birth.
So
and the other one, I ended up dismissing, Your Honor, because she went in for testing the next day.
Okay. So that was back on July the 8th. I rescheduled it for August the 5th. And then it said defendant was in the hospital with her son, and I went ahead and we adjourned this to today's date at 8:30. So with that, Mr. Gay, what would you like to say? I did write a note here, and I cannot read it. It's not good, but I said something. I said she was getting treatment by then.
I think you ordered her to treatment by then, Judge. She did start, she is back in outpatient therapy. She has been going once a week. I believe according to Ms. She did start back on August 8th was her first session. So she is attending 1 time per week. She is back in therapy. Judge, she's making an effort considering her situation with her minor children and the fact that she was just recently gave birth. I would ask the court, Judge, to give her an opportunity to continue to try to fulfill the conditions of her probation. She understands that she's got to be more diligent with respect to keeping her appointments and making her monthly testing. I believe that she will be able to do that moving forward.
Anything you would like to say, ma'am? You know, this case has been going on since 2022. Now, at some point, you either got to decide you're going to fulfill the conditions of probation, we're going to be done with it, or you're not, in which case you're not going to like what I have to do. Tell me what your thoughts are.
Yes, Your Honor. At a previous violation, we did extend her probation out to February 17 of 26. I did get verification from the Guidance Center that she met with a new therapist, Ms. Johnson, on August 6th. I did indicate to them that her previous therapist, Jessica Sims, wanted her in the co-occurring. So I don't have any verification that she attended on August 6th. I have verification that she was scheduled. I'm confident as far as the email that she's engaged in treatment, but I want to make sure she's engaged in a proper level. The outstanding issues on the file, Judge, again, previous violation, you had ordered her to pay $150 a month beginning September 15. As far as the payment plan is concerned, with all monies to be paid January 31. You ordered 40 hours of the community service to be completed by September 15th. And I do want to indicate that she still has those open warrants, specifically the one on the 18th District Court for an assault and battery case. All of those, of course, were overdue at the last violation. We pushed out due to the pregnancy, but I just want to bring that to light of the court because September 5th is nothing but 30 days from now, basically.
5th or 15th?
15th, I'm sorry, 1-5.
Judge, according to Ms. G, she did, the therapist that she met with was supposed to send something out to probation. So she was under the impression that they would provide that proof of attendance.
All right, so where do you suggest we go from here?
Your Honor, again, I feel confident that she's communicated with the guidance center. I communicated back to them in regards to, again, ensuring that she's in the proper level of treatment. The co-occurring program that was recommended for her is for both mental health and substance abuse treatment, something she would benefit from. And that is where you're attending weekly group and weekly individual sessions. And my understanding is that is what they were going to set her up for. So I'm just concerned when counsel indicates that she's going once a week. But again, this is very fresh. If she just resumed August 6th, she wouldn't have anything but at this point, a session or two underneath her belt. I don't know if we need to revisit the money. I don't believe that Ms. G is employed or earning any income at this point in time. And I do believe that September 15th is still a good date for the 40 hours. There's no reason she can't volunteer her time, especially looking back at the original sentencing date and perhaps a new date for open for her turning herself in on her warrant, Your Honor.
You still have to go by the date I gave you, September 15th.
Okay.
Look, I want to work with you, but you're making it difficult. Okay? I mean, I'm gonna give you a break here because I get the fact that, you know, you had a child and all of that, but you have to follow through on these things. And I have a feeling, I'm just looking at your file and you have a history of just not doing what you're supposed to do. I'm gonna let this one go. I'm gonna let it go. But I'm gonna expect full compliance with everything. And if you need additional time to pay, you have to come and talk to me on or before a due date. Do you understand that?
Yeah.
When I say I'm gonna let it go, what I'm gonna do is I will only, give me 1 second here. Yeah. I'm gonna simply say, okay, even though this penalty should be a lot worse, I'm not going to order any I'm not going to order any additional payment. But you now have 9 total violations. 10 is not a charm. You're going to serve 8 more hours of community service on this, but I'm telling you, and I'm not threatening, if you don't follow through by what I've just ordered and everything that we have that you're supposed to be doing with probation and violations, you're going to have a big problem with me. Do you understand what I'm telling you? I'm going to give you to serve these 8 hours of community service until October the 25th. Now, I can't be any nicer than this. But my patience is running thin with you because you're not doing what you're supposed to do. Take advantage of this. If you don't, you're going to regret it. And I'm not, honestly, I'm not trying to threaten you. I'm telling you how it's going to be. Do we understand one another?
Yeah.
Good enough. Stay with me now.
Did you want to give any type of time frame for those open warrants again, Judge?
Well, we said my original order was September 15th, right?
The last violation, you did not address any new due date on the open warrants. You only addressed those dates for time to pay and for the community.
I'm sorry. Well, then I misunderstood a little bit.
I apologize.
Defendant declare all warrants by September 15th. You understand that?
Yes.
You better start going in there, ma'am.
I did. I went to West Wendy, that was 3 different charges. I actually have worked with them.
Let me check something. When did you go there? This was run on August 7th. And unless you've been somewhere in the last week, you still have warrants out of the 22nd District Court for assault or assault and battery out of Romulus, 34th District Court. For a plate violation, you have one out of Romulus for another civil infraction, and you have another one out of Romulus for another civil infraction. You gotta go clear those warrants, especially Westland has nothing to do with this. 22nd is Inkster.
Yeah, I think 18th, I might have misspoke. 18th District Court is for that MDOP, I believe, Your Honor. I think I misspoke as far as what the offense was, but it's an MDOP out of 18th District Court.
Well, here's the thing. Do you want to clear the warrants on your terms where you have time to prepare for everything and you go in voluntarily and get it taken care of? Or do you want to be driving down the highway with your kid in the car, get pulled over, and then get arrested and hauled in because you didn't grow up? And then you got to find somebody to care for your kid, your car gets towed, all that bad stuff. Just, I don't care your preference. Just go touch a pair. Get it taken care of.
What's the date of the lien on yours?
September 4th of 2020.
No. When was the lien run on that kid, on that?
This has been run a while ago, Your Honor. This one was January 30th prior to the last
Okay, so
filing.
he must have taken care of that. August 7th was the lien that I have on my hand here, and there is no indication of a warrant out of Westland, but you do have one out of Inkster and 3 out of Romulus. All right, good luck. Thank you very much. Have a good day. Thanks.
All right, guys, we are going to pop over to the next one. I might have to do a little digging to find the right person, but I had it set.
Oh, let's see. Next that is all of our PCCs. Agreed, Attorney Young?
I believe so.
Okay, and so then we have Mr. Cox, right?
And toast, the one with Toasto we didn't do.
Figure that out.
Yeah.
We'll figure that out. We have Mr. Cox's civil infraction, that's with the city of Burton. And then we have these 1 o'clocks that I need to take care of, but I think Attorney Young, you are set.
Are we seriously dealing with Mr. Cox and Mr. Toast? Cox and Toast.
Right?
No, actually, the Cox matter is a state case. And my understanding is that there's been 2 informal hearings and appeal.
Come on. You know what? Can you let Mr. Stop? Okay. Who is Sandra Francis?
Good afternoon. I'm here on 2 matters, Your Honor, for Capital One Bank.
Okay. If you'll just hold on for me for a minute. We've had kind of busy morning, so I will come back to you.
Okay, thank you.
Thank you. All right, let's just see what's going on here before the court's going to have to take a little break because we have been sitting here since 9 o'clock this morning, and I think we just sort of a little break. But let's see what's going on here first. So 25F00315SI, People of the State of Michigan versus Travis Wayne Cox. And Attorney Young, place your appearance on the record.
Yes, Your Honor. Mitchell Young for the people.
And you star Travis Wayne Cox?
Yes, ma'am.
Okay. And so we're here today on this civil infraction. As Attorney Young stated, it looks like there was an informal hearing. It looks like there was an appeal filed in regards to that hearing. This is a 2 civil infractions ticket, careless driving and no proof of insurance. And then it's like there was a warning on the no ops charge. And so, Mr. Cox, you are appealing the decision of the magistrate at your informal hearing. Is that right? Okay. And the issues up today are both the careless driving civil infraction and the no insurance. Is that right, Attorney Young?
Your Honor, yes, that's my understanding. My understanding is that Magistrate Carey found entered judgment for an improper lane use rather than careless driving. However, my understanding of the statute is that when it's appealed, it's reviewed de novo.
Yes,
So
I agree with that. So what that means is that essentially the entry of this judgment gets set aside and we go back to the original on whether or not you know, had the careless driving or proof of insurance. I might make the same decision the magistrate made. I may make a different decision, but her decision has no bearing on mine. You understand that? Okay. And so, we have been here for a while. I really do appreciate your patience, Mr. Cox. I know it's not easy sitting around and waiting. I've been sitting here for longer than you've been sitting out there, so think about that for a second. Are you ready to proceed with the hearing today, Attorney Young?
Your Honor, at this time, well, I did have Trooper Conquergood subpoenaed. However, my understanding is he is right now on military leave. However, we do have dash camera video. I would leave it to the court. I would request an adjournment, I suppose, if his testimony is needed. I do know, my understanding is he's already testified once. So,
But it's de novo, so I can't.
right. So I don't know if we could just go off the dash camera video or not.
I'll give you a chance, I promise. Chance. Okay. All right, and so then where we are is this, Mr. Cox. You can either, if you want to go forward with the formal hearing today, and just have me look at the video, I don't mind doing that. The parties would have to agree to that though, without the testimony of the trooper. And from either party's perspective, I don't know if that's a good idea or not. I don't know. But if the parties agree to that, that is fine with me. However, I'm not going to dismiss because the trooper is not here because he's on a military assignment. And you can't, that would be inappropriate in regards to the court rules as well as other things. So I can't dismiss it for you. So those are your options. We can either adjourn it to a different day. Hold on, stop. You can't interrupt me. Your choices are go forward today with just the video. If that's what you want to do, no pressure at all, because I don't know if that would be my choice or not, but you can either do that or we can put it on another day when the trooper is back from his military assignment.
I like to move forward today.
Okay. All right, then I'm gonna have you sit down because I'm gonna take care of some of the other people and then we'll come back.
I guess I would request an adjournment. I think it would be beneficial to have.
I was first by this
Hold
guy
on.
inside this room back there.
Stop. Mr. Cox, did you hear me when I
Yeah, I
said,
did.
don't interrupt me? You don't interrupt me, you don't interrupt him, he doesn't interrupt you. We just don't do that in this courtroom. And one main reason why we don't is because there's a recorder and the recorder will not pick up us talking over each other. And you already appealed this, so you're gonna want a good record. So you cannot interrupt people and people won't interrupt you so that we can make a good record. What were you going to say?
Back in this room, back here, he brought me in this room and told me if I take this, he pointed his finger and it was shaking. He said, if I take this to trial, and I didn't let him finish. I said, you're weird. You need to back away from me and let me leave this room. This guy is strange. I don't care what anybody said. You can get in a room with him. He straight up threatened me, like straight up threatened me. I don't take kindly to that, and I will be getting a hold of a few different people and making a complaint with the Attorney Grievance Commission and a few other things in Troy, because you can't threaten someone like that and then pull me to another room and he straight up threatened me. You can ask.
I threaten you, sir.
He said, if you take this to trial with his
You
finger
stop,
just
you
like
stop,
that.
stop talking.
Not a threat.
And you, Attorney Young, you as well. Listen, gentlemen. This is a courtroom, for God's sake. If there has been, stop.
Sorry.
talking.
Sorry, bad thing.
Well, not only that, it's contemptuous. I could hold you in contempt and put you in jail. You don't want me to do that. So just calm down. Shut it and let me finish. This is a courtroom. We're going to conduct ourselves. Everyone's going to conduct themselves as such, which means we're not going to interrupt each other. We're not going to argue with each other. That's not appropriate for anybody to do. We're going to set this for another hearing so we can have the trooper here, because we're not going to punish him for being part of our military. We're gonna come back and we're gonna have a hearing. I'm gonna make a decision and then that'll be it. And if you don't like my decision, you can appeal it to the person above. That's perfectly fine, but we're not gonna do this.
Would I be
okay?
able to show you the video today? So you can at least see what I was charged with, what they wrote on here, what I did and what I actually do?
Nope.
Okay.
No. I do though. I do truly, Mr. Cox. I apologize that you waited this long. I appreciate your patience. I really do. It has been a
Wow.
well, no, not a problem. It's just been a really busy day and everybody's had to wait. We had so many cases up today. Some of those cases took way longer than they should have, but it's just unfortunately what happens. But you're still gonna have your right to have your hearing, and that is the important thing. So, you know what I'm gonna do? I'm actually not gonna give a date right now because my clerks out front are going to be able to better assess that date than I am. So I'm gonna have them file over to them, stop at the clerk's office. They'll give you a new court date. We'll come back on that date. Okay?
Okay, and then you say you're not available next week, not until the following week,
Yeah,
right?
it's definitely not gonna be next week.
Okay, I bought a car.
When is that?
This weekend's one, so you should be back. I should be fine. My
We'll be
birthday
better
is
for
the
you in a couple
22nd. Couple things I have to do, that's it.
Okay, all right, sounds good. Stop at the clerk's office. Thank you. You're welcome. And Attorney Young, then you are finished?
Judge, I want to apologize for that. I'm very sorry.
Okay, I know it gets hard. Frustrating.
Your patience was much better. I do apologize.
Yeah, I must have some decent patience. Everybody's brought it up today.
Yeah. I think we're all set then. We're all set. As far as my case.
Just told Attorney Tolstoy is already out.
Oh, okay. Okay.
All right. This is 25T02169 FD, people of the state of Michigan versus Jacoby David Voorhees, attorneys.
Usually young people.
Good afternoon, Your Honor. John Tosta on behalf of Mr. Voorhees.
All right, thank you. We have PCC today. What are we doing with this case?
Judge, this is the first PCC. I believe I've got all the discovery. If possible, like an exam date, please.
We will set this matter for exam on the earliest date we have is August 26th. Tina, can you find a date for that I'll be here, like the informal hearing that we have time? Yeah, that'd be fine. Thank you.
Judge, I hate to interrupt you, but I just will note, I have an officer that is listed to get a subpoena for exam that will be out from the 25th to the 28th. That's what I have.
Okay, so what if we were to look at, it looks like we could do the September 2nd, September 9th. Attorney Tosto?
September 2nd. Let's see, would those be just mornings or both
Good question. I believe, let me see. I believe that would be all day. We would have all day on the 2nd.
Oh, great. This later in the morning on the 2nd would be great.
That's fine with me. How about 11 o'clock?
Sounds good.
All right, September 2nd, 2025 at 11 o'clock a.m. And Attorney Tosto, did you have any conversations with your client about possibility of sobriety court?
Yeah, we briefly discussed that option, Judge, and it might be the right fit here. So we'll continue with that discussion.
If you, in between now and the next court date, if you want me to fill out a referral for sobriety court, I will be happy to do it. Just let me know.
Okay, thank you. I appreciate it.
All right, thank you.
Bye-bye.
Now Attorney Young, I think you're good.
Much I'd love to stay, Judge. I'm gonna go.
I am pretending that.
I like her.
All right, we have a couple.
Hoping maybe when we get a new attorney, we might put in a word.
You are welcome anytime. I would, I'd love to have a permanent attorney, and for you,
Yeah.
that would just be fun.
Did you see Marshall?
Have a good one. Okay, let's see. Yeah, let's go this. 25F0307GZ GTSC Warehouse LLC versus Tanya Marie and Brian Lee Allen.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of GTSC Warehouse LLC.
Thank you. And we have Brian Allen and Tanya Allen here in the courtroom. All right. So here is where we are and where we are last time. We were here on July 28th and defendant was paid $3,284.82 into escrow with the court. Defendant or plaintiff's attorney to provide a breakdown of attorney's fees. And we would return for a decision today. Is that an accurate statement as far as you know, Attorney Morton?
Yes, Your Honor. Yeah, the decision, the 328482 was not, was it disputed in regards to what was due through the month of July. And then the court should have received our breakdown. I know I mailed, but also emailed a copy to Mr. Allen as well of the breakdown of the legal calculations. We also included the support for the claim, i.e. specifically the contract terms as well as an affidavit.
All right, thank you. And Mr. Allen, what would you like to say? Did you pay that $3,000?
No, I can't get the funds released until 28th is when my institution will allow me to grab those funds. So I can't even do anything until the 25th. And then I would pay it myself, but I can't do nothing until 28th at the financial institution.
So remind me, you stated that you did have the money and that you had placed it into your own type of escrow.
What I did, ma'am, was I had it set up to where it was like kind of like a loan type situation where I had because the vehicle with Creekwood, and this is where Creekwood and this they say is not the same, but it is. So I had it set up to where the funds would be available to me, and I thought they were going to be ready for me before then. Anytime I asked for it, and they said no, they weren't going to be still until the 28th. So
did you get a copy of the plaintiff's brief in support of request for an award of attorney's fees and costs in the accompanying documents that went with that?
I got the email today. I haven't got the thing. They said in the email said something about it being sent FedEx, but I haven't received it by FedEx yet. So
I do note that it was filed with the court on August 12th, so just a couple days ago here. And I'm assuming that you want to respond to that. Is that true? Because that was something you were contesting?
yes, ma'am. Yes, it was in another light of that too was I'm working on the phone records and stuff because I think that needs to be a part of this, and I'm waiting on those records to come back from Xfinity. I had to have because I need them for court, and I wanted to have proof that these are their records, not mine. So because that was a part of this whole deal, that if the attorneys would have responded back in December when they sent the letter that I have here, which I don't think you have a copy of, Your Honor, stating that I need to contact them and everything else. And this is when it all started. And this is when also the stuff with Creekwood started at the same time, right around the same time, where we tried to contact them and everything else, and they didn't respond that one time. And my phone records and everything else to show that they didn't contact us or anything after I reached out at least 8 different times. So
well, I'm just gonna interrupt you real quick because it sounds like we're not ready to forward on the motion yet, and so you need time to do all of that, get that information to me. So I would propose that we are looking at an adjournment on this matter. Attorney Morton?
Your Honor, I feel it's appropriate to say, and again, after the last contentious hearings I saw, I wanted to make sure that I wanted to give Mr. Allen the full chance to be able to speak. I also want to clarify, first of all, his accusations in regards to shared companies and things like that are baseless, and there's no support for that. And I feel it's necessary just to formally put that on the record. Second of all, Your Honor, he violated the court's direction in regards to placing those funds into escrow. He said before at the last hearing, as the court put on the record, that he would place those funds into escrow. He failed to do so. This is a possession-only action for a judgment of possession. I think it's appropriate, and I understand the court's going to weigh different factors. I do think it's appropriate that, that a judgment of possession be entered based on his failure to follow the court's direction in regards to simply placing those funds into escrow. This is a reoccurring theme in regards to statements of offering to make payments and then maybe adjusting the amount he's going to pay and then saying he can pay an amount and then not paying the amount. It's a reoccurring theme, Your Honor, and that was only what was due through the month of July. At the last hearing, and I'll let the court review its own records, the court said, look, there's no dispute. There was a default. The amount due was the amount due. He was required to put that into escrow. He didn't put that into escrow, to just minimally move forward to not have the judgment of possession entered. So as of today's date, Your Honor, I think it's appropriate, and I would ask the court to enter a judgment of possession for this matter. If the court's not going to entertain that today, over, as the court understands, over my request and my client's request for this, I would simply ask that, first of all, there's been another, now we're in the month of August, another $285.86 have come due because that balance that was provided was through July. And this is only for the payments towards the balance due. So we would ask that, maybe if the court's going to adjourn it, an order gets put in place this time, so it doesn't become a continuing issue where he makes a promise that he's not able to uphold.
I thought, did we not reduce what I had stated on the record last time? Did we not reduce that to an order that $3,284.82 would be paid into escrow with the court, and that plaintiff's attorney would provide a breakdown of attorney's fees?
I don't believe that was put into a formal order, Your Honor. I believe based on the turnaround time, the court simply gave the order from the bench and provided that, was it to both parties? If the court put in an order, I would say that and there was an order in place and that order was violated.
There should have been one, and
It was one of the problems I had, ma'am. I thought that I was told that the attorney was gonna do it. And I came in here looking for it and they said it wasn't done. So I had to actually they gave me a copy of this that you put, so I could try to get the help just in case I couldn't get it done. So there was no order done, and just that you put this on file, and that was it. That was one of the problems I ran into too. So I thought the attorney was gonna do it, and that's what I was told by the clerks, but she said.
well, I don't know if I wrote down that or not, so I don't want to say who was supposed to do it or who wasn't. So here's what I'm going to, I'm sorry, Mr. Allen, was there anything else you want?
Yes, ma'am. And just to go back to where he says that there is nothing between the two places, there is, because in my current agreement or contract with Creekwood or with the mortgage company, I can't sell my house unless I let Creekwood have the first option to buy. If they're not in cahoots with each other, then why is it in my contract that I can't sell my house to you or anybody else?
Yeah, but that's not really in front of me right now.
No.
That issue is not those issues are not really in front of me right now.
Well, I understand. Maybe I get that wrong. I'm just saying that they said they're not together, they are.
I mean, if there's some other type of claim, I don't know. There's some other type of claim that you want to make or another type of issue. I mean, suppose you could put it in writing. What I'm going to do is I'm going to adjourn the matter for the reason that the court did not get plaintiff's brief in support of request for an award of attorney's fees and costs. And that's just what's written on the front of what I'm looking at here. I didn't know that this was actually in the file, so I haven't even reviewed it. I know that defendant has not had the opportunity to review it. And so I'm going to adjourn to give the defendant time to respond to that. But I am going to not make a decision. I'm going to note that plaintiff has addressed the fact that defendant didn't put the money into escrow that was supposed to be put into escrow, and I'll make a decision on that issue and whether that is violation of what the court ordered when we come back to court next time. So what I'm going to do is this, I'm going to adjourn this matter to September 8th, 2025, at 10 o'clock a.m. And that will give Mr. and Mrs. Allen you time to respond to the attorney's fees requests. And that will, I'll make a decision at that time whether or not you're in violation of the court order by not placing the money into escrow. You can put the money into escrow between now and then. That would be a smart thing to do because it's still an order of the court that you're supposed to do that. And obviously it's not going to go anywhere when you place it into escrow with the court, right? So it's going to sit there as it should be sitting somewhere right now anyway. But I still need to make a decision on that issue at that time. And like I said, I'm gonna hold my my ruling on that at this point. So, do anybody have any questions about what I've said? No.
Your Honor, if I could just get two clarifications. The first one is, I wanted to clarify two things, I guess. First of all, the 328482, I understand the court's going to reserve its ability to be able to make a determination on any violation that occurred. I want to make the courts aware and make sure the other party is very clear that that was what was due through July, August, and now with the new hearing date coming in September, those amounts will have come due. I'm not necessarily going to amend the attorney fee list, Your Honor, because if the court, the court didn't have a chance to look at it, but there's already governor on the attorney fee capability of a 15% cap related to the total due on the loan itself, which is all in there that the court can review and Mr. Allen can review. So at this point, there's nothing really more that's going to be collectible specifically in regards to the court cost side, in regards to the contract terms that are being followed. So that's in there already. So I just wanted to say that I wasn't going to seek to amend that balance at that time either, Your Honor. And then finally, that I just also want to make sure this was brought as a possession only action. So I know we're going through the amounts to give Mr. Allen potentially the opportunity to be able to continue on with possession of the home and continue the tenancy. But ultimately, depending on where this goes, I think it's been clearly established the default did occur, but I understand the court's procedures and where it's moving forward with right now. I just felt it was appropriate to mention those select things.
And I think those things that you just stated are accurate. And what I'm going to do is I am going to do an order reiterating what was placed on the record last time we were in court. I will also include that August and September. If they do become due, they need to be paid into the escrow as well. And so that those things are clarified.
Thank you, Your Honor.
Okay. All right. Very good. All right. Then we'll see. And we'll put the next court date in that order as well. But go ahead and stop the clerk's office on your way out. Okay. All right. Thank you.
Your Honor, what was that time again? Just to clear.
September 8th at 10 o'clock a.m.
10 a.m. Thank you.
All right. Thank you, everybody. And C25F0995GC Capital One versus Timmy L. Frank.
Good afternoon, Your Honor. Sandra Francis on behalf of the plaintiff.
Great, thank you. And Mr. Frank is here in the courtroom, approaching the podium. This is a pre-trial conference on this matter. And Attorney Fisher, have you had the opportunity to speak to Mr. Frank?
Your Honor, this matter is actually resolved. We did send the defendant a stipulated dismissal, but we never received a signed copy back.
Yeah. I'm sure, Mr. Frank, you don't have a problem with this matter being dismissed?
No, I'm not sure.
I don't think you should have a problem with the matter being
No.
dismissed, right? Like, that's fine if they want to dismiss their case against you, right? Okay, and so the reason it has to be a stipulated order for dismissal is because you did file an answer. Since Mr. Frank is here right now, Attorney Fisher, do you want to email that order to the court? We can print it. Mr. Fisher can sign before he leaves, or Mr. Frank can sign before he leaves, and then we'll get it done today.
I can have my paralegal send it over. I'll send her an email and ask her that she get it over to the court.
Okay, do you want to do that? All right, so just have a seat out in the lobby. We'll get that emailed over and we'll have him sign it and then you'll be all set. Okay, good. Okay.
Yeah. Can I get the email address that it should be sent to?
We will chat that to you.
Okay. And then I do have one other matter, Your Honor, as well.
Okay, C25F0748GC Capital One versus JVMC Hodge.
Good afternoon again, Your Honor. Santa Francis on behalf of the plaintiff.
And you are Mr. Hodge?
Yes, ma'am.
Okay. And I apologize. I know your last name is Francis. I think I called you Fisher earlier because I have that written on my file. Apologize.
That's okay, Judge.
And so we are here today as well on a pretrial conference. And Attorney Francis, where are we here?
Your Honor, I believe we were here back on July 28th. At that point in time, the defendant had failed to appear, so the court indicated that it would adjourn the matter to allow the defendant another opportunity to appear.
True. Okay, yes, I believe so. And I did that, Mr. Hodge, because you had an answer for better or worse in the file. And so I usually give people an opportunity, if they don't appear the first time, to at least appear one more time before I issue a default against them. But it looks to me like you are not necessarily contesting that you owe the money here. It's just you would like to maybe set up some type of payment plan.
Yes,
Is that
and
right?
yes, and I did not know anything about showing up here on the 28th.
Right, well, you got notice of it, so you should have been here, but it's neither here nor there now. You're here now. Attorney Francis,
Yes, Your Honor.
would you, let's see, we can do this one of two ways. We can either have Mr. Hodge, if you're willing to speak to the attorney, we can have you go out in the lobby and they can give you a call and you can try to talk about it right now, or I can adjourn the matter for another period of time and give the parties time to talk outside of court.
Your Honor, I do have another meeting at 2:00. Is it possible I can give the defendant the direct line of our office for the agent that's assigned to his account, and he can reach out to the agent to discuss payment options on the account?
Does that work for you, Mr. Hodge?
Yes, I do.
You have a pen?
Right here, and I have.
It is
Go ahead and give the number.
1-800-594-5018.
And that's a direct line.
Yes, and if for some reason you don't reach the agent, just please leave them a voicemail message and they will get back with you.
Is this to
Weber,
this is to Weber?
Weber and Olsey's office. We're the law firm that represents Capital One.
Okay, yeah, I've called a couple of times. I've never gotten a call back from anyone or anything.
All right, well.
Do you want to provide me with a phone number? I do show one on file. I could have the agent directly give you a call if that's easiest for you.
Yes, we can exchange numbers. That way we can get in contact with each other.
Okay. Now, do you mind me, the last 4 digits showing are 7316 of the number I'm showing on file?
Correct.
That's correct. Okay, I'll have the agent give you a call.
Okay.
Okay.
Okay, then I'm going to adjourn this matter to September 22nd, 2025 at 10:00 a.m. Hopefully the matter is resolved by that time, but if not, we will reconvene at that date. Okay, just stop at the clerk's office on your way out.
Thank you.
All right, thank you.
And sorry, Judge, just quickly, I'm not seeing the email address in the chat for the other file.
Oh, Marcia, did you chat her email? Oh. Yeah, she did not get it. Yes, yes, she did not get it. No, she did not. I'm sorry.
The judge still has to pee.
Okay, I just received it now.
Okay.
I will have my office send that over.
Very good, thank you.
She mentioned it
Thank you,
like
Judge.
5 people ago.
C25F1125GZ, Rebecca McCartney versus Kenneth Kavanaugh. Are those people here? I don't think so. All right, I'll deal with that one later. Okay, C25F1296SC, Edward Lavore versus Doug Bacon, doing business as Ultimate Paint and Body. Come on up, guys. All right, and Edward Labor, that's you, correct? Okay. So let's see. You can have a seat. So, Mr. Labor, this is actually a small claims case that we set forward today. Let's see. Mr. Labor, it looks like you filed an action contracted with Doug Bacon, Ultimate Paint and Body to restore Camaro. Okay. Have you, Mr. Labor, since you filed this action, have you had the opportunity to speak with Mr. Bacon? Since you filed?
Yes, we spoke a few weeks ago when we were here.
Okay, I thought. Thank you. Have you two been able to resolve the matter?
Ma'am.
No? Okay. All right, so since you haven't been able to resolve the matter, and I know you've tried, so that's a good thing. At this point, Mr. Labor, are you wishing to move forward with your small claims action?
Yes.
And Mr. Bacon, are you wishing to move forward today as well?
Yes, ma'am. This matter.
And I know we've talked about this before also, but you both have the right to retain an attorney if you want to. We'd have to move the matter to the general district docket, and that may have been one of the things we talked about last time that we were here. But today, Mr. Labor, are you choosing to represent yourself and move forward on small claims docket?
Yes.
And same question for you, Mr. Bacon?
Yes, sir.
Okay. And Mr. Labor, you need to know that the most you can claim in this case is 7,000. It's actually 7,500 now. You're claiming 7,000, so that is fine. And you both know that in a small claims action, you are not entitled to request a transcript of this action. And so what that means is that if you wanted, a written transcript, we don't do that in small claims actions. If you wanted that, you would have to ask for the matter to be moved to the general district court docket, which would be fine if that's what you wanted. But there will be no transcript generated today. We of course record everything in this courtroom for safety reasons and transparency reasons and whatnot. But no transcript is generated from that recording. Do you understand that, Mr. Labor?
Yes.
And you're still wanting to move forward?
Yes.
And same thing for you, Mr. Bacon?
Yes.
And you're still wanting to move forward?
Yes.
You also understand that if you don't like my decision today, there's no way to appeal it. So there's no appellate process for a small claims action. So what that means is that when I make a decision, that's it. That's all there is to it. You got to live with it. If you wanted the ability to appeal my decision today, you could have that ability, but again, you would have to ask for the matter to be removed to the general district docket. And so, Mr. Labor, do you still want to move forward today, knowing that you won't be able to appeal my decision?
Yes.
And same question for you, Mr. Bacon? Okay. Way we are going to do this, Mr. Labor, I'm going to have you speak first. Tell me why you're here and what you want. That's the time that you can show me any evidence that you might have, any documentation, any witnesses you might have brought, and tell me what your side of the story is. And then, of course, Mr. Bacon, I will give you the opportunity to then say your piece as well, and provide me with any documentation or evidence or witnesses that you might want to provide me with. Mr. Labor, it's your case, so you get the last word. You'll be able to make a statement after Mr. Bacon does, and then I will give my ruling. Once I give my ruling, nobody else gets to talk or say anything else. You got to make sure you tell me everything you want me to know at the time that you have to do so. Okay, Mr. Labor, do you have any questions?
I do not.
Okay, Mr. Bacon, any questions?
No, Your Honor.
Okay, so Mr. Labor, you can come on up to the podium. Raise your right hand for me, please. Do you try to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, go ahead and tell me why we're here.
Back in 2018, contracted with Doug at Ultimate Paint and Body to restore my car. And we were met after delay, after delay, after delay. Some of them I understood. COVID. He got COVID, he got in a wreck, was injured. His main employee quit. But after a point in time, when I was visiting the shop, the car started to go backwards instead of forwards. He kept repainting. And I started noticing things that just weren't correct. When I picked up the car in April of 2024,
For a moment, I thought he literally meant the car was driving backwards instead of forwards. Not just referring to the paint job. Sir, you are in court. Please be literal.
The tow truck driver was putting on the truck, we're noticing rust. We're noting paint, flaws in the paint, things that just weren't done. That were done, but then were not done again. So there's rust on the car. There's no paint on parts of the car. There's parts missing when we got it home. My brother and I, when we got it home, we just started noticing things left and right. Original parts that were missing, new parts that were missing, parts that were damaged, safety parts that weren't on the car. The first thing we tried to do was start it. Found out that we couldn't start the car because the gas lines were switched. In other words, the supply line and the return line were backwards. So we got that corrected. We noticed the fuel line by the gas tank was pinched. Fuel line to the carburetor was twisted and pinched. We got that corrected. We put on a new fuel pump because the fuel pump that they put on, claiming that it was bad, was put on incorrectly and wasn't pumping fuel. The gas tank wasn't attached properly. It just had a drywall screw holding up the brackets that hold the gas tank on. The grounding wire wasn't even attached to the gas tank. We rebuilt, my brother rebuilt the carburetor twice, couldn't be rebuilt. To make the car start and run, I took it into a shop, they replaced the carburetor. Took it to another shop because they thought it was an engine problem. They verified it was the carburetor, had it replaced 3 times. Because the shop got the wrong one twice. We found wires spliced in the engine compartment. We had to buy a new battery twice. The negative battery cable wasn't connected. The hot positive wire was connected to ground, sparking when we turned the key. We kept looking and looking to see what else on this car was incorrect. We found the copper tubing to the heater core damaged. The radiator overflow tank was missing.
I mean, this sounds like an awful lot to go through. To what? I mean, didn't he took it there for a paint job and like, what are they doing? Like harvesting car parts like human organs? I don't get this. I'm kind of confused at what the motive here is.
Fan shroud was broken, the fan blade was broken. The fan blade was also installed backwards. Spark plug wire separators were missing, so all the spark plug wires were laying on the engine. Fender shields were missing. We continued to make notes and take pictures and make notes and take pictures. I'm still making notes and taking pictures of things that aren't correct on the car. I did have the car into another body shop. I was able to get it there. And they looked at it and says, we can't fix the paint. We have to repaint because all the blemishes on the car, there's 2 or 3 spots on the fender, spots on the door, spots on the trunk. He says, I can't patch it and repaint it. I've got to repaint the car, which was kind of brokenhearted. But the gas pedal wasn't attached. The gas bracket was missing. The steering column brackets are missing. Floor vents are missing. The heater floor vents are missing. I can't even put the seats in because the framing pieces under the car have been damaged, where the seat bolts go in to hold the seat to the frame of the car. New holes were drilled into the floor pan and not attached to the frame. The passenger side, the place where you screw the bolts in, there's no threads anymore. So I can't even put the screws in to hold the seat down. When you put on the old door panels, you put screws through them to hold the door panels onto the door. When the car was in the shop getting the new carburetor put on, it had rained, and when I got the car home from there was rain in the engine compartment, rain in the passenger compartment, rain in the water, not rain, but water in the trunk in those 3 places. The rear bumper isn't on properly because I can't take the lights out of the back to change light bulbs. because he's got the bumper up too tight. And there's no way to get light bulbs in the back taillights without taking the bumper off, right? Bumper cover wasn't attached, the left front fender's not attached. Page 3, yeah. The wiring is not correct. There's wiring that's not even attached to anything. So the car's got to get rewired, and there's parts missing to what they connect to, like the buzzer under the driver's seat. So when you're sitting there and you don't have your seatbelt buckled, there's no buzzer anymore. The left door doesn't even open and close. I mean, I got to lift it, open and close it. So there's just so many different things with the car. When I approached Doug about a year ago or earlier this year, he said he'd call me back and he never did. They addressed these issues in writing to him and he just didn't call back ever. So I didn't have any other course to take. The estimate to get the car painted correctly and get the rust off the car, and these are new parts on the car, the new fenders, the new quarter panels are rusting. Inside the left front fender, you can see where there's paint on top of tape and dust and all kinds of things. The body shop estimate was over almost $13,000 just to fix the paint. Plus to get the parts that are missing back on the car. He was supposed to give me pictures of the progress. He was supposed to give me receipts of the parts that were purchased that I paid for. And that was important to me because I bought the car when I was 18 years old. I bought it brand new and I wanted to document the restoration. I've had the engine restored, the transmission restored, and everybody I took it to gave me documentation to restore the car. But I did not receive that back from Doug or Ultimate Paint and Body. I've got the original contract at $28,500 is what I gave him to restore the car. That included labor and parts. I've got the estimate from the body shop and what it will take to fix the paint. I've got estimates on parts that I know are missing. I've got receipts on parts I already bought, work I've already had done. And I have pictures. All kinds of pictures. You'd like to see them.
Everything you get.
Doesn't include the new ones, Your Honor. That was just last week.
And so tell me one more time, you said you paid Mr. Bacon, how much money did you actually pay?
$28,500.
$28,500 is what you paid to him was it a full restoration?
It was a full body restoration. There was some rust on the car. One spot was really bad. I admit it. Doug saw it when I took it in. He goes, "That's really bad." I said, "I know." But
That's why you paid $28,500.
$20,000 for the labor and parts. Yeah.
But if it was just a body restoration, why would they even have had to go into the engine for the spark plugs and the filters and the gas lines and everything else that you rattled off? A body restoration doesn't involve any of the engine components.
Said I owed him and I gave it to him so he could buy the parts as he went along.
Okay.
I'm confused.
You said work was to be completed and looks like here it was says to be completed by June 2019, but there were complications and you got the vehicle back in April of 2024.
Correct.
And so then these other bills.
Those are some of the parts that I purchased that I had to purchase either twice because they're missing. When they gave them the parts to put the seats together, I don't have those. So I'm buying parts to try to put it back together. So there's parts I've bought twice.
And then this Beckwith's Body Shop is the estimate
Yes, sir.
from the,
Was able to get the car going enough so I could drive to the closest body shop.
and this is their estimate of what it would take to right now make the car into what you want it to be. Is that right?
To get the car into the shape that it should have been in.
That's the $12,934.34.
That's just the body shop and the paint work.
6 years he had that vehicle. I wouldn't trust anyone who kept my vehicle for 6 years repairing it. I would have gotten my vehicle back long before then, because it doesn't take 6 years to restore a vehicle.
That's not all the other stuff.
Okay, and then you said the pictures are just some of the or not some of, it's like a lot, but the various things that you stated weren't right when you got the vehicle back. Is
Yes,
that right?
that's correct.
You do have all of these labeled with different indications of what they are and the things circled that are wrong, right?
Correct.
Okay, and so you're asking for $7,000 to recoup the costs for everything that you just explained to me, is that right?
To recoup some of the costs.
Some of the costs, yeah. I mean,
To get the car so it's safe and drivable again.
and you're asking for your costs as well, which costs $40 for the process server. And then $70 to the court, is that right?
Yes, sir.
So the total amount you're requesting is $7,110. Sound right?
Yes.
Okay, anything else that you would like me to know?
I'm sure there is, but I can't remember it all because it's been overwhelming.
Okay, all right, go ahead and have a seat.
Thank you.
Mr. Bicken, come on up to the podium. Raise your right hand for me, please. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
Yes, sir.
Mr. LaVore, I swore you in, didn't I?
Yes.
It's been a very long day, gentlemen. Okay, thank you. All right, go on, tell me what you want me to know.
I've been up since 3 o'clock, so I'm there with you.
So you're feeling me. Okay, all right, go ahead.
I have multiple pictures of the car from start to finish here. You never know when you're doing a car. First off, I didn't say I was going to restore the car. On the work order, it says paint the car, replace the parts that are needed. This got to be a real project, as you'd be able to see from the pictures. They're 8x10, so you can really see what I had to do.
Do you want me to have them right now, or do you want to bring them up to me after you're done?
Is there a couple just to show you how extensive it was?
Okay, go ahead.
Okay, we got the car in there, started taking it apart, and everything started falling off. I mean, you go and the A-pillars were rusted real bad. The hinges had to be replaced. I put down that I would take the interior out, and Mr. Vore said he was going to take it over to Flint Auto Upholstery over there to Craig. And I said, well, that's good. That was, they were supposed to put it all back in, not us, but all the plastic was actually deteriorating. It was falling apart, so they had bought all new plastic and I dyed all of that and put it all back together. And the black, the interior was black almost. It was supposed to be light blue, and I scrubbed it myself. The floorboard, we had to replace everything. I mean, we had actually built the car. We had to we had to put in a whole new trunk floor, inner tubs. We had to put new quarter panels on. We had to put new B pillars in. We had to replace the rocker panels. Had to rebuild the doors. And I went out, found 2 decent GM fenders. And I cut the bottom off and replaced the bottoms. Pictures are in there, rather than put some aftermarket cheap thin ones on there that don't fit right. As I've restored a few of these. And I've been doing this for 55 years, so I restored quite a few Camaros and Firebirds and show cars. So this one was really complicated. We got into the engine and we took the engine out, which we don't do mechanical, but we can remove an engine because the guy that was there knew how to do that. We needed to get it out of there. Well, the radiator, I pulled it right off the car with my hands. It was all rotted completely. Shields, which are the inner fender wells, the whole front was gone. It was rusted right off. You could see the ground. So I ordered new ones for that. You have to paint all parts before you put it back because they all have to be cut in. The hood was bad. It was rusted and you would go to pull it down and it started bending. Looked on the internet for a decent hood. They want $1,000 for ones that were worse than what I had. So we actually took and rebuilt all the, well, there's fold joints on them. I don't know if you're familiar with them, but there's fold joints. If the car gets an accident, it folds up around the center pot area. So we rebuilt all that, little pieces of metal, weld and grind as well. The whole interior floorboard had to be replaced. The kick panels up there had to be replaced. Now, in front of that firewall, there's 2 big pieces that were completely rotted out. They look like Swiss cheese. They don't make them. We had to go out in the middle of winter where I found one because I know a guy that owns a junkyard way out there that has some old cars. We found a Camaro out there. So we got it. It was frozen in the ground. So he had his forklift to break it out and we replaced those panels. That's what holds up the frame behind the motor. Behind that, the transmission, there's 2 more joints. My guy went to take the bolt out and I almost had an ocean shot because it just missed his head by about the whole frame fell off the car. And Ed said, I was wondering why I was wandering all over the road when I was driving. I said, that car could have killed you because it's all rusted out. There was nothing holding it. Frame in, but a couple of rusted out bolts. So you can't get a frame. You can go out to junkyards and look, but those cars are pretty well gone. The holes that hold the mounting bolts and rubbers and all that in were completely rusted out. So we had to order a kit and weld to make a square plate. So we had to cut the holes out and weld those all in and
You definitely don't want holes in your rubbers.
rebuild. We sandblasted the frame, painted it. Everything underneath was painted when we were done. The cable for I think it was the accelerator cable or the shifting cables, they were all rusty. We got some new parts and stuff for those because it wouldn't shift. Boy, put the motor in that back in. We got it running. I put new wires on it and put some plugs in because I know how to do that from being a teenager. And the old cars, I fixed my own cars. I love restoring cars, but you know, it's tough to do. And there's a lot of body work involved, especially when you're doing that much. It took me a long time. And as a lot of people, I got COVID, so I was down for a while there. In my accident, as he mentioned, it took me 2 years in therapy to get my neck to work right and keep from getting my headaches, but that just slowed me down, that's all. But I have to be out there to when my guys are doing things, but I can't always be out there. That accident caused me times where I had to go in and just stay in my office and sit down. I'm 76 years old, so it really takes a toll on me sometimes, crawling on the ground and things. It's not an excuse. I love what I'm doing. I just finished the 67 Buick Skylight convertible. I'm just finishing it now. I was working on that early this morning so you can go down with your brakes. I've just restored a lot of cars, but this one was the worst. I mean, everything was rusted out, everything in the car. You can't tell that when you're looking at them because they're all together, but even the back panel where the taillights are, where the bumper bolts up. Well, I didn't actually put them taillights and stuff in, so I don't know what went on, but I told, when he came in with the paperwork and stuff, I told him, I says, well, I got a right to see a car or, bring it back and I'll fix anything that you have a problem with. I mean, I'm not a bad person and I don't do the whole car myself. If I spent that many years on a car, building a car completely, that's a lot more than $1,000 restoration. I had the receipts for the parts. He never asked for them. I told him I'd give him the pictures and stuff. Those that you're looking at when he's done, when I'm done with it, then I do that for a lot of people. I've got pictures of probably 30, 40 cars that I've got cars that went down to all around. It's just something I really like to do. But if a person has a problem and I really like that, I've known his brother for a long time. But when I told him that I would fix it, he says, I won't bring it back here anymore. I'm taking it someplace else to fix it.
I've always wanted an El Camino, and like the likelihood of finding one nowadays is minimal. But that's like my dream car is a purple El Camino. This makes me rethink wanting a classic car.
Well, what am I supposed to do then? I know what's going to happen. And that's right, exactly what I figured, I didn't say, well, I said I would look it over and then I get with you, but why, when he walked out like that and told me that he wasn't going to have me do anything, he wasn't going to let me see the car, wasn't going to bring it back so we could go over it, and I could work with him with it. That's the problem we had there. And I did a lot more. You're looking at a $50,000-$60,000 deal because it wasn't supposed to be a rotisserie restoration. That's
So this is what the car looked like when it started. Is that?
no, it was a put together car, but it was quite rusty. But you can't see behind all the areas that had to be fixed.
This is the.
I can't see that here.
Is
It's pretty close. That's when we cut the quarter passes off.
First
16
picture?
First, the back panels, the whole trunk floor that we cut out. We had to take the back panel out of here. So we put the trunk floor in back the way it's supposed to be factory.
Okay.
There's a thing you have to do, especially when you're state certified, have a license. We did it correctly. You have a little wander all over the road now.
Okay, so this is the closest thing we have for the most part of what it looked like. And you have a picture too. I'll have you bring that to me in a second.
There's a picture there in 8x10s of when he told me he was picking it up. I said, well, I'm not really done. I need to go over everything. And he said, I'm picking up. I'll be done to get it 2 days. I said, okay, well, then I told him when he left. And my guy heard me, he says, well, Doug, you told me. if you find anything wrong with it, bring it back and we'll take care of it.
So this is what it looked like when it left your property?
I had a hard time finding
This-
parts for that car, yes.
What it looked like? Okay.
Even the paint, where they say they got to paint over. That's not true at all. I fix them every day. And blend, especially when it's regular old white like that, clear coat. That car is relatively done in lacquer. So. Like the 67 I'm doing right now, it's done in original black because I graduated that year from high school. And the guy asked me, I says, I was working on them in a body shop back in 1967. In that car.
Okay, all right. Anything
Okay.
else?
No, that's about all I can say.
All right.
A lot of work. And I would have taken and fixed the things that he's talking about because I don't do everything. Or I wouldn't even have a body shop. That's why you have people helping you. You just don't always, once it's put together, you don't know exactly what they've done. It's aggravating after all so many years.
All right.
Thank you, Gordon.
You're welcome, Mr. LeVar. Anything else that you would like to say or would like me to see that you haven't already said or shown me?
Well, just if you want to look at the car, what it looked like as I brought it to him, this was in my driveway, but that's what it looked like before he started. And if you swipe, you see the other side of it.
Swipe this way?
Yes.
Okay, so it really had to be taken apart. Kind of to the bones to be put back together. Would you say that's pretty accurate?
I'm not a body shop guy, but conversations with Doug, yes, I would say that's fairly accurate. At the same time, you know, he saw the car, he looked at it, he inspected the car. Some of the things that he said, weren't quite accurate, but, you know, I did ask for receipts, never got one from him as far as the parts. I was under the impression until just now that he bought new fenders instead of cutting out a piece of a fender and putting it in. The floorboard is not new. Piece of the floorboard is new under the driver's side. But the floorboard is not new because I can see the rust that's coming through on it. And as far as the interior goes, it's black because the new parts I purchased come black and they have to be painted. And when I asked him about that, he says, I asked him if, because he said he didn't do the interior, he was gonna put back the original parts. So if I buy new ones, will you put them in? Then he said, I'm paying them for you because it's taking so long. But I bought the new parts that were supposed to be put in. And the radiator I put in, so I know that wasn't rusted. The fender shields are felt, not metal. But the car is just not put back together. And there's so many missing parts, there's so many parts that are safety issues that were on the car that weren't rusted, that were good condition. That car was a complete 100% running car. The shifting cables, it's a 4-speed, it's got a linkage, they're not cables. But he even said over time, it's taken so long, I've got some, you know, the interior was going to do free. And as far as paint goes, from what the people at Beckwith's told me, because I even asked them, why can't you just fix the parts that are bad or fix the parts that have no paint? He says, well, here on this fender, you've got this spot and this spot and this spot. So if we touch all that up, it makes more sense just to repaint the fender so they can get the paint to match correctly. And when Doug said, well, if there's any problems, bring it back. Well, if it was a little bit of this and a little bit of that, I would have said, okay, let's get it done in a month. But as I started looking at the car and looking at the body, looking at all the missing parts, everything that makes this car unsafe to drive right now,
All right. Here, this stuff was yours. I'm sure you can go back to. There was a lot of stuff and we don't want to forget to get it back to them. So I'm gonna give you yours back. I'm gonna give you yours. I have let's do all of it.
I do have pictures probably of When I first got it, he showed you this.
Okay,
And my brother was present for most of these conversations. Like, it's gonna be anything, Your Honor.
well, that's up to you. I hear from whoever you want me to hear from. So if there's anything additional, I don't really need to hear. Like, yeah, that's what happened. I know.
Well, I don't think the issue is, excuse me, I gotta get it.
Yeah, well, I have to swear you in and everything if you're gonna actually speak, so.
Apparently with like $30,000, they will.
All right. You want cartwheels by now, there?
Just walking this road.
Would you prefer to sit or do you want to stand?
Stand for a minute.
Raise
If
your
I
right hand.
get something to hold on to, I'll be all right.
Sure. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do it.
All right, tell me what you want me to know.
I don't think there's an issue here that Doug did some work on the car. However, the work isn't done properly where the fenders aren't attached to the front fascia. There's bolts missing. And the brackets that hold the steering column onto the vehicle are also missing. And the steering wheel just isn't safe to drive because it moves so much. And we cannot bolt the seats to the floor because of the brackets that go across the bottom of the frame are 1.5 inches farther front. So there's nowhere to put the bolts into the floor pans. There's no question that he did some work, but he just didn't complete the work. It's just uncompleted.
Thank you. You can have seats. All right, now is the time that I am going to give my ruling. Anything else from anybody before I start talking?
No, Your Honor.
No? Anything, Mr. Bracken? No? All right, so here's the problem. And there's a lot of problems with situations like this, but here's the main problem. Is one, you start with something like this vehicle, which needed a lot of work. Everybody agrees with that, a lot of work. And a lot of work was done as just stated. And so many times I find in this court, people don't agree with what should have been done, what was done, what could have been done, what was the best way to do it. And people end up happy. I can say this, looking at the pictures that everyone has showed me, I agree, a lot of work was done. I mean, to look at the before and the after picture, I mean, they look like two completely different vehicles. There was so much work done on this car. To bring it into me and for me to try to determine whether or not that was $28,000 worth of work or not, I would have to have an expert testify to that. And we don't have an expert telling me that today. I have an estimate from another place that says this is what they're going to do. But the estimate doesn't actually say that anything was done wrong. It just says this is what we're going to do. And that's not enough for me to determine whether or not there's fault or not. People expect perfection from the restoration of an old car like this, and that is never going to happen. Perfection is definitely never going to happen. And to have to completely rebuild a car for me to say whether or not, $7,000 of the work that was done wasn't done right or was done right or is good enough or not good enough, that is not based on the information that I have from both of these parties, anything that I can make a determination on today. $28,000 was paid. Was that amount of work done? Probably is where I'm going with that. based on the pictures that I saw and the amount of work that was done. I mean, a lot of work was done. Was it done up to the standard, Mr. Labor, that you wanted it to be done? I don't know, but the end result in these type of cases is you have the company that says, this is what we do it on a regular basis, this is what we did, here are the pictures of what we did what we were paid to do, here it is. And then you have the owner of the vehicle who is not an expert that says, well, I don't like it. And it's not enough to get to the point where a court can award money. You have to bring in something other. It's got to be an expert. It's got to be, I have had cases before where they brought in paperwork where the company, and then they brought in somebody from the company that says, this was done wrong. This is why it was done wrong. Let me explain to you why. And this is what we had to do to fix it. Those are the cases where people get awarded the money they're asking for, because they're able to show that definitively. And someone is willing to come in and say, they messed up. This is how they messed up. This is how I had to fix it. But to just have an estimate from someone else, it's not enough. So I'm not saying one person is wrong or right necessarily in this situation. But the burden, small claims is not as, I guess you would say, rigorous. The rules are not as rigorous as what they are in a general district kind of case. But there are still rules and there are still standards that we have to apply. And I just, under these circumstances, I cannot get to that level where I feel comfortable awarding anyone anything or saying one person is necessarily right or wrong. And so at this time, I am going to, after trial, dismiss the claim. It is dismissed with prejudice because I did hear the whole case today. And I just hope that Mr. Labor, you don't have to put in too much more money into the car to get it where you want it to be. The other thing that I was going to say, I apologize, I meant to say this earlier. When you have a situation like this, you do have to give the person who you claim made the mistake an opportunity to cure that mistake. And I don't find that was done today either. So, all right. So the matter is dismissed with prejudice after trial. I'll fill out my form and everybody can get a copy of this. Okay. All right. Thank you, everybody. Thank you. Is the air conditioner not open? That's what's happening. No, oh, I am so hot. Maybe it's just because I've been sitting here, but.
She has been on the bench a long time today. Yeah, she's been up there 2.5 hours now.
Duration of the
This guy wasn't interesting. The next guy was a happy story. And I was gonna start there. And then I saw and then
All right.
the one
Good
where it
luck.
started.
Yes, really. Yes. I look forward to seeing you. Okay.
Thank you, Judge.
Thank you.
Martha, thank you, Merle.
All right. So our three trials are finished. I appreciate everyone's patience. It has been a very busy day. We can bring in anybody that's here for a PCC and we will do those cases. And I know we have 10 o'clock. We had 10 o'clock formal on a civil infraction, and I will, since that looks like it's going to be an actual hearing.
When we watched it.
I will handle that when we're done with our PCC. Okay. Coming into the courtroom, PCCs.
You guys want to stay on her or should we go to a different judge?
Okay. Jan, you are here for PPCs?
Yes, Your Honor, I am.
All right, I appreciate everyone's patience. We have had a lot. Cases this morning. You ready to do PCCs? All right. You need a minute. Oh, okay. Right, looks like we're set to go. Okay, I'm going to call Mr. Sixby's case first because I know that he is here and he is ready to go.
Thank you.
You are welcome. All right, and so this is case number 25T01947FY, people of the state of Michigan versus Robert Wayne Sigsby. And counsel, you can place your appearance on the record.
Good afternoon, Your Honor. Mitchell Young for the people.
And Mr. Sigsby, you can state your name, please.
Robert Wayne Sigsby.
All right, and
Executor, beneficiary, kind of formal.
all right, and we are here today on a probable cause conference. We had a hearing on July 31st. At that point, Mr. Sigsby had stated that he was going to be wanted to represent himself. We had a long conversation about that at that time. And I did determine that Mr. Sigsby would be permitted to represent himself and that Attorney Hilliker would no longer be appointed on the case to represent Mr. Sigsby. And so then at that time, Mr. Sigsby, you stated that there was some more discovery that you were looking for, body cams and some other things. And so we adjourned to today's date. And then we find ourselves here today. So on that note, Mr. Sigsby, do you have all the discovery that you were looking for?
I do not. I wanted to confer with the prosecutor and I had more paperwork to turn in and I worked tirelessly to get the paperwork in. I got it in. There was no more overnight mailing. So I got it in on Tuesday. I don't know if the prosecutor, David Layton, had received the add-on to the paperwork. I see this prosecutor here has zero paperwork in front of him.
He won't cross the bar. Full soft sit, guys. Full soft sit.
So he didn't even get the first paperwork or all of it was sent in. I don't know, Mr. Prosecutor, did you receive any paperwork?
I think they do everything they have a system called Carpel where they do everything digitally. So if he does have a digital file with your paperwork in it, probably
It looked like this.
I believe, Attorney Young.
Your Honor, I'm unaware of anything that was given to our office. My understanding is that Attorney Hilliker provided all the discovery that we gave to him, to Mr. Sigsby, and from there he has everything that we have at this time. We did provide Attorney Hilliker the body cam of Officer Isaiah Voorhees, and that is all I have in regards to body worn camera at this time.
But
Yeah, I want to be respectful.
thank you.
So what I said in the last PCC, seeing as how we don't have a Fifth Amendment indictment here, we're going through this process. I feel it's very constitutional not to have an indictment. There was supposed to be body cameras from the other officers, roughly between 9 and 12. I could hardly count how many police were there because of what has happened on the side of the road. It would exonerate me if I had different views of the behavior and the actions of the arresting officer in this civil infraction.
All right,
The
so
fruit of the poisonous tree has been definitely happened.
Your Honor, if I may, I'm obviously not an expert on the facts of this case as I'm just covering today, but my understanding is that the body cam of the arresting officer was provided, being Isaiah Voorhees.
The fruit of the poisonous tree. has been definitely happened. It's not how that goes. It's not even close.
If I may.
Okay, well, hold on, let me ask a question. So on that one body camera of the arresting officer, do you have that, Mr. Sixby?
I do.
Okay,
And
so
what-
you have the one, it's just the other ones that you.
Right.
want. Okay.
Exactly, because what the deputy did is he concealed he put his body camera on this side of me and blocked it while he reached into my bag and into my pockets. I was cuffed. And he reached in the pocket. I looked down and seen him pull out my Native American herb. And then he stuffed it back in my pocket, but I thought he took it with everything else and threw it into the vehicle. So that right there would exonerate me that I did not bring nothing into the jails. He did.
No malice.
Okay, nope. Mr. Renfro, you don't have any standing to talk, so I'm gonna let you stand there, but that is all I'm gonna let you do. You can't say any words today.
I am appearing next, friend.
You are not, because that is not permitted by the Michigan court rules. You can stand there, like I said, I'll let you do, but if you keep talking, I'm gonna make you sit down, and then if you don't follow those rules, I'm gonna have those nice gentlemen back there escort you out of the room,
Thank you.
okay? So, remember, my rules, my court, it's just how it works. Okay.
Objection. I'd like to have an objection.
Sure.
The definition of court here is the person in suit of the sovereign, the place where the sovereign sojourns with his regal retinue. This is my retinue. Blackwell's dictionary is cognizable by the Congress.
All right, this is the 67th District Court. I'm the judge of the 67th District Court, and that's all I'm gonna say about that. Okay, so whatever that objection is, it's overruled. Okay, let's get back to the issue at hand, though. The issue at hand is that Mr. Sixby would like some additional body camera footage. Attorney Young, I know that you weren't here last time on this case, right? It was a different, I think it was Attorney Farmer, I think.
I believe so, Your Honor.
All right.
It's either him or Attorney Bocarakis.
So here is what I'm going to say today, what I'm going to order today is I do think that it is relevant, and I think that it is pertinent. If there are other body cameras available of officers that were there on scene, then I do believe those need to be turned over to Mr. Sixby, because I do find them to be relevant. And I think that it's not unreasonable to want those things prior to the preliminary examination. So I am going to order that those be turned over. I'm also going to state, though, that the discovery is what the discovery is. And so sometimes there are situations where people think there is additional discovery that does not exist. So if there is 5 body cameras, then there's 5 body cameras. And if that's what the prosecutor's office says that that's all they have, then that's all they have. So we're gonna order that everything the prosecutor's office has needs to be turned over. If there are additional body camera, they need to get that and they need to turn that over. But we're not going to continue to have a conversation over and over again about discovery that needs to be, or that discovery that Mr. Sixby you think might exist that doesn't exist. So when we come back next time, I'm going to expect the prosecutor's office to turn over everything they have, and then we will move on to the preliminary examination phase, because we got to start moving this case along at some point.
So Michigan.
Hold on one second. Attorney Young, how long do you think it will take your office to get that additional information for Mr. Sixby?
Seeing that this is the Genesee County Sheriff's Office, I should be able to get it relatively quickly. However, the videos would need to be reviewed prior to release. I'm thinking 2 weeks would be more than enough time. I could probably do it if I'm lucky by the end of this week, really, to get them. So I'll leave it to the court and I'll get it done. But I'd say either a week or 2.
Right.
Mr.
Sixby?
So the problem I have is, a couple of them, is one, Michigan State Constitution says I get to confer with the prosecuting office. I'd like to do that.
Sure.
And then another thing is on a scene such as that one, you'd think every one of these cops would have, excuse me, police officers would have their body cameras running. So if he wants to look at them ahead of time and said there is none, no evidence, I'd say that was conspiracy against my rights at that time under United States Code 18 U.S.C. 241.
But we're not even there yet.
I get it, I get it. But okay, the video I got, there's a chunk in there where he says if this man would have been by himself, I would have, and it went blank. You can see the lips moving, but you can't hear nothing. So the editing process is taking away exculpatory evidence.
Those are things, so
If he
those
threatened me with death,
those are the things, whatever happened, those are the things that get brought up in front of the jury. You can bring them up in front of your preliminary examination as well, but they get brought up in front of the jury to show weight of evidence. If you're claiming there's evidence that's missing and things like that, those things absolutely can be brought up. It's just that we're not going to prevent having a preliminary examination by saying that you think that there's evidence out there that they're saying that they don't have. Do you see what I'm saying? So once they say, this is all we have, these are all the cameras, then we are going to have the preliminary examination. That's all I'm saying. So we're going to give you time to do that though, and give you time to talk to prosecutor's office.
Was it missing or did he mute? Because there's a big difference. You say that you can still see his lips moving. That would lead me to believe that the officer muted. Not that there's a chunk missing. Big difference. You can't restore something that's muted. And I mean, I'm sure the officer didn't want his job at put in jeopardy from saying something like, I'd have bashed his face in or something like that. The cops are human. I mean, I don't know if y'all realize that, but cops are human. They go through the same emotions that you and I go through, like, the road ragey effect. It does happen.
Once you have that information. All right. So having said that, let's pick a date for the next court date. I think Attorney Young, you're right. I think to get the information to Mr. Sigsbee and then give Mr. Sigsbee and prosecutor's office, everybody time to review everything and then give the parties time to talk if they want to. I think that setting this for one more probable cause conference, I will find good cause to do so. I do think that's a good idea. And I'm looking at September 4th. Does that sound like a good day to everyone?
well, I'd like to get 21 days so I could send the prosecutor a proper notice of non-response.
That is appropriate.
Oh, you got good math.
Do you want, I can give you a little bit, we can put it on the 11th.
Well, I would like it on the 11th. The reason being because I'm going to send a bill of particulars. If this county does not recognize Fifth Amendment indictment, then they're going to have the bill of particulars because without that, the substantive due process has been violated on space. There is no indictment on this felony charges, and it is the fruit of the poisonous tree. So I'm concerned that the Constitution of the United States is not being followed on its face by all parties. It's a point of order.
So
Point of order is a real, I got to get it out of the law book again?
I've looked at Mr. Sigsbee, I've looked at everything that you filed. In fact, not only have I looked at it, I've highlighted it, and I've even made my own notes.
I see you.
So please know that I do read everything that's put in front of me and
That's
I take
blessed.
it seriously.
Thank you.
But a lot of what you filed is not relevant nor pertinent nor accurate law in any way. And a lot of it too, it's not filed properly in the sense of this. You have to file it as a motion. So if you do have a motion, we'll hear your motion at the next court hearing, okay? But it has to be filed as a motion. For example, some of these things like a judicial notice of adjudicative facts, notice and demand to cease and desist inland piracy.
I'm not an attorney.
Hold on. I'll let you say it when I'm done. It's nonsense. It's nonsense and I'm not going to address it.
cease and desist inland tyrancy. Oh my God, this gets better and better.
Notice of document filing, things, affidavit of truth. One thing I did want to point out to you, you filed your birth certificate in this file. This is a public file. So people could go and get a copy of your birth certificate because it's right here in this paperwork. I would have not done that. I'm not giving you legal advice in any way, but that just doesn't seem like that's a good idea. I just wanted to point that out to you because when I saw that, I thought, that's not. I also have this appearance of next friend and these things they're just not.
Their Supreme Court.
Hold on, stop. I'm gonna let you say those things in just a second. They're not permitted under the Michigan court rules. There's no statute that permits things like this to be filed, and frankly, there's not going to be. I'm not going to spend a lot of time addressing them because they're not relevant to these hearings in any way. I just wanted to let you know that.
All right, I object on the record, be reserved on the record to correct the record. The Supremacy Clause of the United States does bind you to all of this. Article 6, Clause 2, you're in breach of that clause for saying Michigan does not recognize these. You guys are foreign citizens. Title 28, 22, United States Code, Foreign Relationship and Intercourse. Chapter 11 identifies all public officials as foreign agents. Federal Rules of Civil Procedures 4J states that all courts, jurisdictions, and immunities fall under foreign state. 22 CFR 92.12-13, Foreign Relationship state an oath is required to take office. The 11th Amendment, foreign citizens cannot invoke the judicial powers of the state. 28 USC 3002-15-8 defines the United States means a federal corporation. Michigan is a franchise, and so is this subdivision is a franchise of a federal corporation. Corporations have no parity with the tangible in Howard versus Dolan's administration. Governmental actors are foreclosed from creating and attaining parity with the tangible. These are res judicata, Supreme Court laws of the land. Now, I'd say that was treason on its face. The judge has just committed.
Yeah.
Well,
I've been accused.
I'm a living man.
Stop. I'm talking now. I've been accused of committing treason before, not committing treason. Everything you just said is nonsense and it is not applicable in this court. We're going to leave it at that. We have a court date now set for September 11th, 2025 at 11 o'clock a.m. That will be a probable cause conference. We will be, hold on, let me see where we'll be. We will be back here in Burton on that day. So we'll be here in Burton. For probable cause conference. Any motions that anyone wants to file, try to get filed by that time, though I'm not doing motion cutoff or anything of that nature, but it'd be a good time for us to discuss those things. We're not going to discuss any of this again because I have addressed it and found it to be irrelevant to this criminal case today. And anything else from anybody?
I do.
Yes, Your Honor, just briefly. As is our typical office policy with pro per defendants, I will, once I have the body cam for Mr. Sigsby, I'll have it on a flash drive and I'll hand deliver it to him in court at the next court date. It seems to be the best way to give that discovery. Unless it's another idea.
Can he pick it up at like a clerk's office or something like that?
I don't see why not.
The problem is that we're gonna adjourn it out almost a month. And
Yeah, I don't see why
we're gonna
not.
Adjourn it again for him to review it, so I don't like that idea.
And I guess I just don't know how I would, well, I think Mr. Hilliker gave us his address. I don't know how I would be able to contact.
Mr. Sigsby, what's your opinion on that?
Well, yeah, I don't want no improper service here, Michigan.
Let's.
If there's
see
gonna be an
what-
issue with
How do you
service.
want it, how do you want it provided to you?
I will meet up with him at the conference. I'd like to have a conference with the prosecutor.
Well, you're
Well,
gonna.
it says so.
Schedule
Says so in
that.
Michigan State Constitution, that we pull out paperwork.
No.
They just-
No, stop. All we're talking about, I'm not talking about conferences right now. I'm just talking about getting discovery to people. So if the prosecutor's office You know what? No, we'll do it this way. It's the only other thing we can do is I'm going to move the PCC. We're gonna have a PCC on August 28th, 2025 at 11:00 a.m. That will be to exchange discovery. Okay. So that way we can do it here in the courtroom. There won't be any questions about it. I don't want to put any staff member in a precarious position being accused of things that not delivering things or something along those lines. I don't want to put anybody in that position. So we'll just come back here on August 28th, 2025, 11:00 a.m. We'll have a very brief probable cause conference, and that will only be to exchange discovery. If there are any other issues in regards to discovery, we can talk about them too. And then we'll also have another PCC on the 11th. That will give you opportunity.
That answered my next question. That did answer my next question.
Okay.
Okay, because I just want opportunity, and I do object to the prosecutor using the pro se. I'm not pro se, I'm sui juris.
Sure.
Thank you.
However you want to say. Representing yourself, sui juris, pro se,
Myself,
On
I'm not
myself.
civil war too, so I'm not a civil debt.
presenting myself, all those things. They all mean the same thing. Okay. Thank you, everybody.
Okay, thanks.
Oh my goodness, my face hurts.
All right, now let's go. I think everybody else is here. Or you need folks here for.
Oh my God. Oh my face hurts. That was glorious. Oh, I knew that was in there somewhere. I knew that was in there somewhere. Oh my God. Sweet. Oh golly, you guys, that was so great. The judge isn't the only one that's had to pee for a while. I've had to pee for the longest time, and I couldn't walk away from that one. I could not go. I could not leave that one alone. That was freaking fantastic. Oh, I had such a blast with you guys. Oh, I'm about ready to tell you some of my personal persona. Oh my God, you guys, this is great. You guys are so freaking fantastic. But now I have to edit that so that I can get it out as a video and, actually make money on it, because I don't, my live streams aren't monetized. That's why I do the replay crew videos too. So, yeah, now I got to get that going. All right. So you guys will see that one pop up very shortly. Yes. I was just expecting to have the arrogant defense attorney, and then I had an okay one from Clallam County, and a couple other things that, nothing, super, super great. That was what I had in this courtroom was my best. That's what I had the best. And yeah, that turned amazing. I was like, oh, I want to go back and just see what she had prior to the hearing that I started off on. I knew you guys love the stuff I started on, but I hadn't checked out the earlier stuff. So yeah, I just had that spidey sense feeling. Yeah, that's such a great sense to have. One of the best soft sits we've seen in a long time. Oh my goodness, I'd love to see him in front of Ricky. Yeah. Maybe Stevens. No. You know what? Put him in front of Judge Colin Hunter without Colin Hunter shutting it down. Like, actually make him make the arguments. I think, just for my entertainment value, that's what we need. We need judges to stop shutting these soft sits down. Let them make their arguments, because I want to hear it. Wait for the replay crew mini. Give me like a half hour. All right, guys. I love you all so much. Oh, then I gotta switch my media asset back to the PAWFURM. I switched it the moment he went full soft sit. All right, guys. Thank you so much for coming out and hanging out with me. This has been an amazing blast. Be safe, be well, sleep sweet, and much love.